We are going to start our morning session. Datuk Dr. Ahmad Faruq Musa, the Director of the IRF. Professor Datuk Dr. Shad Saleem Faruqi, our distinguished speaker for this morning session. Speakers, all the participants, and my fellow friends. I would like to welcome again all of you in this conference on religious freedom in 21st century. And thanks again to all of you for spending your weekend with us today. And in this opening remark, I would like to brief about what we are working on in IRF before we start our morning session. Actually, we in IRF, as stated in our slogan, for those who think, لِقَوْمِ يَتَفَكَّرُونَ, it encapsulates the message of to bring forth the discourse in our society that recognize reasons, rational thinking, and as such. And we also keen to promote the discourse about democracy, freedom, and human rights, and the discourse as such. Before I pass this session to Ihsan, I want us to bear in mind and to realize that this is a kind of very important program in this age that we are living in. We must realize that we live in a society where extremism, bigotry, and very much and so many unacceptable acts that happen all around us nowadays. Every day we heard about so many issues ranging from religious tension and racial sentiment that's been played around every day, and that's why this kind of conference about religious freedom is very important. And before I left this floor, I would like to promote some of our some of our material that can be accessed online. Firstly, you can access our website at www.irfront.org.my for our articles and so many things that can be accessed there. And furthermore, you can also view our videos of previous program that we organized. There are so many topics discussed in there, and you can access online. That's all for this opening remark, and I pass this floor to Ihsan.
Bismillahirrahmanirrahim. Thank you, Shamil, Chairperson, for the session. Prof. Shad, Datuk Dr. Faruq, distinguished speakers, fellow friends, participants of the conference, freedom of religion in the 21st century Muslim societies. Well, Shamil have gave us a brief introduction, mainly addressing some points that It is an important event, and one of the reasons there's a lot of issues and terrible events happening related to religion. While we all know, I think at least those who still strongly confess and those who still strongly hold strong religious values would agree that religion is basically a very important tool for us humans to live in this world, not just individually, but as collectively, and how we deal with different communities, including different communities of faith. However, if you go back through history, there's nothing for even religious people to hide. There's so many issues and conflicts between one religious community to another. In fact, this could also relate within religious communities themselves. Muslims with Muslims in wars, Christians with Christians in wars, and this also happens in other religions as well. Because of that, it's always important for us to be reminded to know that the level of respect and tolerance and the principles of religious freedom is indeed very important. So from this basic background, in early 2016, we were reminded again of the need for religious freedom with the pronouncement of the Marrakesh Declaration. For those who are familiar with Marrakesh, it is a town, a city in Maghribi. So several scholars, in fact, a lot of scholars coming mainly from Muslim countries, various Muslim countries, they gathered together and they came up with a pronouncement, a declaration. This declaration is mainly inspired essentially by the Charter of Medina, as mentioned by Prof. Chandra yesterday, and an endorsement of religious liberty to all regardless of faith, by no other than our beloved Prophet himself, the Charter of Medina. Peace and blessings upon him. And this is a charter which is so important around 1,400 years ago, and it is still strongly relevant at the current time. The Marrakesh Declaration, inspired by the Charter of Medina, calls for different segments in Muslim societies to play their role and take action in promoting religious freedom. Among others, some of the suggestions are Muslim scholars and intellectuals should develop jurisprudence of a common citizenship, which is inclusive to all religious groups. Second, educational institutions and authorities should review the education curricula containing elements of aggression, violence, and extremism. Politicians and decision makers to take the political and legal steps towards fortifying relations and understanding among the various religious groups. The members of the civil society should establish a broad movement that acknowledges the rights of religious freedom to all in Muslim societies. To get more detail, I'm sure even most of you might have already read through the declaration in full. In fact, I think IRF and also perhaps one of our participants have also translated into Bahasa so that this declaration can also be read for Malaysians to know that it is not just a call for Muslim in Malaysia, but it's actually a global need for this declaration to be promoted. So, understanding this, let's go back to the Malaysian context, at least. As Prof. Chandra explained in quite detail yesterday, religious freedom, it is an important ideal for Malaysians in our constitution, in our Rukun Negara. In fact, I attended one conference a few months back, the resurgence of Islamic spirit, the revival of Islamic spirit, in which in one of the sessions, Professor Hamza Yusuf, I'm sure most of you are familiar with him, he in fact put Malaysia as a very good example where Marrakesh Declaration is actually lived and practiced. We can see it in a good way, as Malaysia in general, we have yet to have any serious conflicts related to religion, at least over the past several years. However, there are still issues whenever we want to talk about religious freedom. We know a big issue which is on the usage of the word of Allah among non-Muslims, as an example. And then the treatments towards minority Muslims. either the Shia groups, even now the liberal groups as well, and the Ahmadi group for quite a number of years ago. And from time to time, there will be circling issues, sometimes repeated issues being discussed and time again. And if we go back to even recent, I think over the past few days, the controversy of YB Hanayo because of her book, is being seen that she shared her own, in some way, her own religious experience. Even that became like a controversy to a point of lecturers, scholars made a police report because being seen as this is a kind of proselytization towards Muslim. So in some ways, are we really actually practicing religious freedom in a very good way, or what are the limitations? So this kind of discussion is important, and because of that, this declaration, Marrakesh Declaration, again needs to be understood and reviewed in our current context, because it is not new. If some of us can recall, quite a number of years back, even Malaysia, under the Prime Minister of the time, Datuk Seri Abdullah Badawi, and Khairi Jamaluddin at that time, he endorsed the Aman Declaration, in which there is a clear statement of harmony between inter-Muslim sects. But even that, in recent times, we can see the situation is not actually being practiced well. So, on this brief introduction, I would like to invite you all later to contribute as well in this session by Prof. Shad Faruqi. Mainly the title is The Marrakesh Declaration and Religious Freedom, the Legal Challenges in Malaysia. Just a brief background of Prof. Shad Saleem Faruqi, even though indeed he requires no introduction. He's a professor of law who has served Universiti Technology Mara, UiTM mainly in Shah Alam, Selangor in various capacities from 1971 onwards. I believe now you're in University of Malaya. Yeah. Prof? Yeah. He specialized in constitutional law and human rights issues. He is the author of Human Rights, Globalization and the Asian Economic Crisis, Islam, International Law and War Against Terrorism, Islam, Democracy and Development, Document of Destiny. There's quite a number of lists of the works by Prof. Shad Saleem Faruqi. He has contributed over 350 articles for legal periodicals, anthologies, and newspapers, and has presented over 300 seminar papers in 15 countries, including the US, the UK, Australia, Germany, and Japan. And I'll just end up. This is going to be his next latest presentation. No further delay, I pass to Prof. Shad Saleem Faruqi. Thank you.
Bismillahirrahmanirrahim. Assalamu alaikum rahmatullah. Peace be upon you all, and good morning, ladies and gentlemen. I thank Dr. Farooq for the honor of this invitation. We have a really sublime topic for discussion in this seminar, and last night some of the issues were highlighted. A question was asked as to what's the concept of religion, how can religious freedom be secured internationally and domestically, what is Islam's attitude towards religious pluralism. And during Dr. Chandra's presentation, he gave us some very exquisite passages from the Holy Quran to prove that the spirit of the Holy Quran is not just tolerance, but also respect for other faiths. At the same time, we cannot deny that the unfortunate reality is that a wide gap exists between theory and reality in most of the 57 or so Muslim majority states, including our blessed nation. But I must quickly point out that this gap between pious pontifications and sordid realities exists in almost all societies, including those of the liberal democracies of the West. So, for example, in the European Union, where there is a great deal of protection for freedom of religion, there is also a great deal of hate speech. The gods and prophets of many religions are vilified, and that is regarded as part of free speech. Unlike in Singapore, where if you attack another religion, the long arm of the law will reach you. So in that respect, And may I also point out, while there is respect for freedom of religion at home, it appears to be maybe a coincidence that many of the nations being attacked by the USA today, from Afghanistan to Iraq, to Libya, to Syria, to Yemen, to Somalia, Sudan, somehow they happen to belong to one particular religion. Now that is just a coincidence, isn't it? Now my job today is not to go into the international aspects, or for that matter, Islam. My job is narrower, and that is to examine Malaysian constitutional theory and contemporary reality in Malaysia, and to make some observations about how to recapture the spirit of compassion, accommodation that animated the founding fathers of our constitution, and I believe is also part of the traditional Malay culture. In constitutional and international theory, freedom of religion is a combination of many separate but linked freedoms, including freedom of speech, freedom of assembly, freedom of association, and, though this is controversial, freedom to disassociate, that is to have the right to change one's religion, right to buy and administer property for religious purposes, and right to religious education. All in all, and though I know this is a very broad generalization, all in all, Malaysian constitutional theory complies substantially with the above requirements, though regrettably there is some regression since the late 80s. Let me point out to you some of the main provisions of the Constitution which deal with freedom of religion. Article 3, Clause 1, though Islam is the religion of the Federation, all other religions may be practiced in peace and harmony. Unlike in Indonesia, and I don't mean to condemn Indonesia, it's a different approach. In Indonesia, the Constitution lists a number of recognized religions. In Malaysia, the approach is Islam is mentioned as the religion of the Federation. All other religions, without being specified, are allowed to be practiced in peace and harmony. Which approach is better? I leave that to you. Now, along with Article 3, Clause 1, that Islam is the religion of the Federation, there is a clear provision, Article 3, Clause 4. Nothing in this article derogates from any other provision of the Constitution. What is clearly implied is that you cannot rely on Article 3, Clause 1 to take away, to undermine any other right or duty or institution that is established under the Constitution. So, hypothetically, no one can go to the courts and say this law is un-Islamic and therefore unconstitutional. The courts will say the litmus test of validity or constitutionality is not Article 3, Clause 1 Islam, but the Constitution. And we had a clear-cut case on this point in the case of Che Omar Che So, 1988. A drug law was challenged as unconstitutional because it had some un-Islamic provisions. There was a presumption of guilt, presumption of trafficking, and the law was challenged. Because in Islamic criminal law, there is no presumption of guilt. Everyone is innocent till proven guilty, like in common law countries. Tun Saleh Abbas, a well-known Muslim jurist, he said, even if the law is un-Islamic, the test of validity is the Constitution. Under Article 149 of the Constitution, there is a law against subversion, and as long as the Dangerous Drugs Special Preventive Measures Act is permissible under Article 149, it is a valid law. So the litmus test of constitutionality is the Constitution and not the theory of Islam. No one, for example, can go to the court and say hereditary monarchy, parliamentary democracy, or parts of the penal code are un-Islamic and therefore unconstitutional. The court will say, refer to the constitution as the legal filter through which a law must pass. So I think that's the implication of Article 3, Clause 4. Religious pluralism is accepted. Despite many problems and some regressions, Malaysia has a record of religious tolerance that should be the envy of many plural societies. Just 2 months ago, we came back from Iran. Dr. Farooq was also there, and one of the Iranian professors began his presentation by saying to all of us, the Malaysians, he said, you know, we used to look up to you as a model of a country where democracy and development, religion and secularism can go hand in hand. And then he paused and said, but what has happened to you? So for a long time, actually, we were the envy of many plural societies. Mosques, temples, churches, Sikh gurdwaras dot the landscape. Citizens celebrate each other's religious festivals. Unlike in some democracies like India, which has many other very positive features, but sadly, religious riots erupt with painful regularity. The present Prime Minister, when he was the Chief Minister of Gujarat, is actually complicit in the killing of about 3,000 Muslims in communal riots in Gujarat for a time. For a while, he was actually barred from entering the United States. Holy places of minority religions are often razed to the ground, and then also there are Western societies where religious minorities are constantly caricatured in the media, and their gods and prophets are vilified in the name of free speech. Now, don't get me wrong, I believe in free speech, but freedom per se has no value. It's what freedom is for. It's the use to which it is put. It's the sense of responsibility and restraint with which it is exercised. You don't have to promote your religion by denigrating other religions. So I would again repeat, I like the Singapore model, but when it comes to hate speech, they come down hard. I don't know if there are any Singaporeans present here. I'm not trying to get a PR in Singapore, not at all. So I think all in all in Malaysia, there is much religious friendship and tolerance. We may not love each other, but we don't kill each other. No religion, no race, no region is at war with each other, unlike in some other nations where actually there is a great deal of religious strife, communal strife, or regions are at war with each other. Now, even though Christians constitute less than 9.5% of the total population, most hotels in the cities carry copies of the Holy Bible in every guest room. I'm not criticizing that. I think that's beautiful. At the same time, the Muslim Qiblat, direction in which Muslims offer their prayer, is compulsorily shown in every room. Muslim, Buddhist, and Christian and Hindu festivals are marked by national holidays. Please recommend a few more religious holidays so we can maintain our world record of having the largest number of public holidays in the world. Please do that. Christian and missionary schools abound. Christian missionary teachers are often retained until age 65. Actually now our retirement age has come up to 60, but even when the age was 55, Christian missionary teachers were retained until age 65. There's a Malaysia Ministry of Education, secular, KP, etc. like that. My daughter was studying at Asunta Primary and Secondary, and I remember very much Sister Enda, an institution by herself. Yes, indeed. Though Islam is the religion of the Federation, several laws provide for non-Muslim religious institutions. There are about 9 or 10 laws about non-Muslim religious institutions. I think the overall approach to religion in Malaysia is that the state is not indifferent to or neutral towards religion. It permits and promotes religions. It believes that tolerance comes not from the absence of faith, but from its living presence. Sharia courts, as part of our legal pluralism, more than one legal system, Sharia courts are permitted, but with limited jurisdiction. Schedule 9, List 2, Paragraph 1 of the Constitution says, Sharia courts shall have jurisdiction only over persons professing the religion of Islam and in respect only of any of the matters included in this paragraph. There are 24 plus 1, 25 matters included in Schedule 9, List 2, mostly matters of Muslim personal law, mostly. And Sharia courts have jurisdiction only over these issues. Article 8, Clause 2, there is no discrimination to be allowed. Article 8 is the article about equality, no discrimination on grounds of religion. But I have to quickly point out, but this protection gets diluted a little bit because of Islam's exalted position in Article 3, Clause 1, and also because of the grant of special position to the Malays, who are all, by constitutional definition, adherents of Islam. Article 11, Clause 2, 11, Clause 1, the Constitution gives to every person 3 types of religious freedoms: the freedom to profess, to practice, and subject to 11, Clause 4, to propagate. So profess, practice, and propagate. And that's the definition of freedom of religion under the Malaysian Constitution. Article 11, Clause 2, there is to be no compulsion to support a religion other than our own. But I suppose you can be forced to support your own religion. So Muslims can be forced, at the moment they are not, but they can be forced to pay zakat fitra because the protection is to support a religion other than your own. However, indirectly, of course, income tax being used for religious purposes, Islamic purposes, indirectly people do support other religions, but no direct taxation is permitted. Article 11, Clause 3, every religious group has the right to manage its own affairs. Article 12, Clause 1, there is to be no discrimination on the ground of religion in relation to the rights of students to admission of fees in educational institutions. Last night, Dr. Chandra Muzaffar pointed out there was 95% literacy. When it comes to primary, secondary education, it's almost free. And I was jokingly pointing out 95% literacy, but I don't know what percent of education. That I don't know. Because literacy and education are 2 separate things. Article 12, Clause 2, every religious group has the right to establish, maintain institutions for religious education. 12, Clause 3, no person shall be required to receive instruction or to take part in any ceremony or worship of a religion other than his own. So again, there is this issue of other than your own. The Constitution is built on the assumption that most citizens have a religious belief. Article 8, Clause 2, there can be no discrimination on the ground of religion against employees in the public sector. Let me skip that. Now, obviously, no religion, no right can be absolute. So there are limits on freedom of religion. Article 3, Clause 1 says you can practice your religion, but you cannot disturb peace and harmony. Article 10 is about free speech, but obviously all restrictions on free speech will indirectly also restrict freedom of religion. And there are severe restrictions on free speech, about 14 of them. Article 11, Clause 4 says propagation of one's religion to others is allowed, but this right is subject to one important limitation. Missionary activity amongst Muslims by anyone may be regulated by state law. It says may. Actually, in 1957, there was no such regulation, but ever since the case of Joshua Jamaluddin in the 80s, state after state, and now 10 out of 13 states have state laws restricting the preaching of religion, any religion, to Muslims. For the benefit of my non-Muslim friends, I must point out 11 Clause 4 is not just to restrict or prevent non-Muslims from preaching to Muslims. Even a Muslim cannot preach to Muslims except without accreditation. So for example, I am a Hanafi Muslim. If I were to start preaching Hanafi doctrine to Dr. Farooq, technically I could get into trouble. In fact, I'm a little bit worried. I don't have a Tauliya. Tauliya is the accreditation that must be. So Article 11, Clause 4 is quite broad. Its purpose was basically to regulate what is called often deviationist practice. But 11, Clause 4 is being abused by many religious authorities to suppress any diversity of religious ideas. 11, Clause 5, all religious freedom is subject to public order, public health and morality. I think that's unobjectionable. Anywhere in the world, public order, public health, morality are grounds for restricting religion. And of course it creates sometimes painful problems. For example, Jehovah's Witnesses do not want to have blood transfusions. Sometimes they don't want to have inoculations. A parent may not want to send his kids to normal school, but the country may say education is compulsory, and if you deny your kids education. So there are such issues which arise in every country. Atheism, sadly, the protection offered by Article 11 is only against a religion other than your own. So these provisions pose problems for constitutional rights of non-believers, atheists, agnostics, freethinkers and rationalists. However, I have to point out this to you. This does not mean that Malaysia persecutes or prosecutes atheists. I don't know of any criminal law case where an atheist has been prosecuted or persecuted. In practice, these people are left alone. And to me, as a student of law and jurisprudence, the law is what happens. Law is not only found in the statute book. The law is what happens. Law consists not only of legal norms, but also non-legal practices. So I think all in all, there's really no great issue about atheists, agnostics, freethinkers, and rationalists, unless they are Muslims, in which case I think the control is rather severe. A departure from freedom of religion would be that our ICs require us to state our religious status, and I think that's a violation of international law, because in international law, no one can be compelled to reveal his thoughts or adherence to a religious belief. Minors and their rights. Under Article 12, Clause 3, the religion of a person under 18 years is to be decided by his parent or guardian. This is the case of Teo Eng Huat, a Buddhist girl, aged 17, wanted to convert to Islam. Her parents objected, her father objected, and the court said the father has a right to object because she is a minor. Now, many of you will support this decision that minors should follow their parents. I just want to point out to you that in the US the approach is different. It's not majority and minority. In the US the test is, has the child reached the age of discretion? The court decides whether the child has reached the age of discretion by interviewing the child in chambers, asking him whether he or she understands the implications of his action. Where will your pocket money come from? What if your father doesn't support your education? How will you live? How will you eat? So the courts decide, and it's up to you which approach you adopt, whether it should be the approach of Teo Eng Huat or whether it should be the test of the age of discretion. Now there are many matters of concern. Sorry, may I just go back on this point, because to many of my non-Muslim brothers and sisters, Article 12, Clause 3 is a matter of great concern. Sadly and shamefully, very shamefully indeed, this has happened, that in many non-Muslim marriages, one party converts to Islam, and immediately after that, takes the kids to the Sharia court, gets the Sharia court to convert the child to Islam, gets custody, gets guardianship, and gets the marriage dissolved. I'll be saying more about that later on. The issue that has arisen is this. The non-converting spouse says, this is my child also. What about my wishes? And the federal court, in several cases, has interpreted, in my view, misinterpreted Article 12, Clause 3 like this. They say, oh, in Article 12, Clause 3, the word is that the religion of a child under 18 years will be decided by his parent or guardian. Parent or guardian is singular. So one parent is enough. As long as the father says, that's enough. Now, with all due respect to the federal court, maybe the lawyers in the case were not mindful of the 11th schedule of the Constitution, which has an interpretation chapter, which says very clearly, singular includes plural, plural includes singular, male includes female. Now, anyone who knows law will know that laws are drafted in a particular way. We normally draft law in the singular. No person shall be deprived of his life or liberty save in accordance with law. We don't say all persons. We don't say all persons, whether male or female. No. Normally law is drafted in the singular, and I apologize for that. Law is drafted in the male tense. Maybe it should change, but they don't want to say all persons, comma, whether male or female, comma. So that's the way. So I think the court is shamefully unaware of Schedule 11, and maybe the lawyers did not brief the court on this point. To me, ignoring the mother in a case like that is, besides a violation of Schedule 11, it's also a violation of Article 8, equality before the law. How can the mother be less important than the father, or father less important than the mother on the issue of the upbringing of the child? Recently, an issue was raised by some Muslim religious groups. Oh, there is a fatwa. There is a fatwa which says if one parent is a Muslim, then the children are automatically a Muslim. Yes, I acknowledge there is such a fatwa, but with all due respect, let me point out to my Muslim religious friends, I'm sure there is also a fatwa in the Catholic Church, by whatever name called. I'm sure there is a fatwa in the Catholic Church and a fatwa in other churches also, that if one parent is a Catholic, then the children must be Catholic. To me, the issue is this: how can a fatwa apply to Indira Gandhi? How can a fatwa apply to a non-Muslim woman? A fatwa applies to Muslims. A fatwa cannot determine the rights and duties, the marriage, the custody, the guardianship, issues relating to a non-Muslim. So I think on this issue there is a clear misunderstanding on the part of religious authorities of my religion. They believe that they pass a fatwa, that fatwa can determine the rights and duties of non-Muslims. With all due respect, I don't think that is permitted by the Constitution. The religious authorities have rights only over Muslims. They have no rights over non-Muslims. There are many matters of concern to non-Muslims. Sharia courts should apply only to those professing the religion of Islam, yet many Sharia courts are dissolving non-Muslim marriages if one party converts to Islam. You know, it doesn't make sense for a Sharia court to handle a marriage where one party is a Muslim, one party is not a Muslim, because the non-Muslim is not eligible to appear before the Sharia court. So some of my Muslim brothers and sisters give the argument, well, though she is not eligible, she can appear before the Sharia court. With all due respect, that's a bad legal argument. Jurisdiction is a matter of law, not a matter of acquiescence. So I agree to appear before a martial court, martial law court. I agree. But they have no jurisdiction over me because I'm not a member of the armed forces. The martial law court has no jurisdiction over a civilian like me, even if I agree. So Sharia court has no jurisdiction over non-Muslim. Whether the non-Muslim agrees or disagrees, that is irrelevant in law. Article 121(1)(a), Sharia courts are within their jurisdiction, independent of the civil courts. This law was enacted in 1988 or so for a good cause. It was happening, in fact, that there'll be a Muslim dispute between Muslims over inheritance or over a Muslim will, wasiyat, and the matter would go to the Sharia court. Sharia court would make a decision. One of the parties would go to the civil court and have the Sharia court decision overturned. Now that was a little bit unacceptable, that the civil court, often headed by a non-Muslim judge, would override a religious court better trained in the Sharia. So Article 121(1)(a) was enacted, that the High Court, the Court of Appeal, the Federal Court shall have no jurisdiction over the Sharia courts in matters within their jurisdiction. So Sharia courts are independent only in matters within their jurisdiction. So questions of jurisdiction are always there to be explored. Sadly, what is happening is Sharia courts are now behaving as if they are immune from the jurisdiction of the High Court, etc., in any matter where there is the smallest whiff, smallest element of Islamic law. And that's not correct. Sharia courts, for example, are trying homosexuality cases. Now don't get me wrong, I'm not supporting homosexuality. What I'm saying is this: homosexuality is a penal offense under the penal code. It's called carnal intercourse against the order of nature. So it is an offense under the penal code to be tried by the ordinary courts. Sharia courts have no jurisdiction whatsoever to try homosexuality, whether committed by Muslim males or Muslim females. So there is this excess of jurisdiction. Because it's a Muslim matter, therefore Sharia courts have jurisdiction. Also, please bear in mind that sometimes what is happening is not just Sharia courts, Sharia officials, administrative officials are behaving as if they are immune from the jurisdiction of the High Court. So Sharia officials will go raid a Christian church to seize Bibles in Bahasa Melayu, or they will go raid a Hindu temple to stop a marriage from taking place because one of the parties to the marriage is allegedly a Muslim. Now, with all due respect, the ecclesiastical authorities of one religion should not exercise power over the places of worship of another religion. I think that, to me, is basic cardinal principle, that religious authorities of one religion should not be invading, raiding the holy sanctum sanctorum of another religion. That's a no-no. But that's the way it is happening. To me, Schedule 9, Paragraph 1 is crystal clear that Sharia courts have no jurisdiction over non-Muslims, and as such the decision by the superior civil courts to hand over cases where one party is a Muslim, the other is a non-Muslim, hand over these cases to the Sharia courts is a very serious abdication. Serious, irresponsible abdication by our superior courts of their judicial oath to preserve, protect, and defend the Constitution. I wanted to point out this issue. Painful issues are arising when one partner in a non-Muslim marriage converts to Islam, goes to the Sharia court, ex parte. Ex parte is only one party is heard to dissolve the non-Muslim marriage. I'm sorry to say this, not in all cases, but in some cases, some non-Muslim persons who want to dissolve their non-Muslim marriage don't want to follow the strict procedures of the Non-Muslim Marriage and Divorce Act 1976. They find the easy way out, convert to Islam, go to the Sharia court, get the marriage dissolved, get custody, guardianship, get the children converted. This is an abuse of Islam that should not be permitted. I think the Sharia courts should put their foot down and say, have you settled issues of property, other ancillary matters, you're welcome to come and join us, be our brother. But have you settled your responsibility to your non-Muslim wife? Islam does not permit, cannot permit such irresponsible behavior of just dumping your wife, going to the court, getting converted, and just leaving the wife absolutely without any rights whatsoever. I also pointed out Article 121(1)(a) immunizes Sharia courts within their jurisdiction, not outside their jurisdiction. Article 120(a) immunizes Sharia courts, not Sharia authorities. I pointed this out, conversion to Islam to avoid liability in a civil marriage, application of fatwas to non-Muslim, that's not allowed by the Constitution. Sharia authorities like JAIS raiding the Bible Society, I don't think that's proper under the Constitution. In the Herald case, the Superior Civil Courts upheld the Home Minister's order to the Christian newsletter to desist from using the word Allah in their reference to God. Now, I've been asked this question by my Muslim and non-Muslim friends. Personally speaking, if you examine this issue of Kalima Allah from many perspectives, the linguistic perspective, actually in the Arabic language, the word Allah precedes Islam. Prophet Muhammad's father had the word Abdullah in his name, Abdullah. So the word Allah precedes Islam. Arabs use the word Allah all the time. They say, MashaAllah, Jazakallah, Bismillah, Alhamdulillah, and many of them are Christians. I met many of them on trips to Saudi Arabia, met many of them when I was seconded to Islamic University in Petaling Jaya, now in Gombak. That's their language, that's the way they talk. Sabah Sarawak Christians have used the word Allah. By the way, in the Sikh Guru Granth Sahib, the word Allah is used, I'm not so sure 30 times or 35 times, but in the Guru Granth Sahib, the word Allah is used. The Hindus will often say, Ishwar Allah tere naam. Ishwar is God and Allah, of course, is God. Your name, you have many names. One name is Ishwar and one name is Allah. So, this is a unnecessary dispute. Unilateral conversion of minors, I think that's a very serious issue. It doesn't make sense for a Sharia court to handle a case like this when one party is a non-Muslim. I think the issue must be handled by the civil courts. The conversion part, that's the Hindu husband's right, yes, but the conversion of the children, dissolution of marriage, it must be done under the civil law under which the marriage took place. If I have a contract with you, Dato, the contract must be modified or rescinded under the law under which it was framed. I can't have a contract with you under the Contracts Act and have it amended under some other law. That's not quite right. In this country, interreligious marriages between Muslims and others are not allowed. Actually, Islamic law, classical Islamic law, is much more broad and liberal on this point. Muslim males are allowed to marry Kitabiya women, but I know that in Malaysia that's not the interpretation. Interestingly, very interestingly, custom versus religion in some states like Negri Sembilan, even in the matter of family law, Islamic rules are overridden by adat. And what is most amazing from a jurisprudence point of view, custom is administered not by customary courts, but by Sharia courts. Now that's the remarkable jurisprudential issue, that in Sabah Sarawak there are native courts to enforce native law, but in the state of Negri Sembilan, and actually in many other states also, my wife is from Malacca, so in Malacca also partly, in some areas actually, Sharia courts will handle customary issues. And in the matter of family law, custom overrides religion. But in Sabah Sarawak, there is intense competition. We don't talk about it, Dato, we don't talk about it, but my students have done research. In Sabah Sarawak, there is intense competition between native law and Sharia. Muslims, many Muslims would rather go to native court rather than go to Sharia court, and there is that dispute. Since the 80s, Muslim religious extremism is on the rise, and sadly this is impacting not only Muslims but also non-Muslims. Hotels and houses are raided by religious vigilantes to catch Muslims committing sins. Dress codes requiring Muslim notions of modesty are being imposed on non-Muslim women. During the fasting month, restaurants are put under pressure to close down during the day. I can't understand that. I'm fasting, why must restaurants close down, especially those serving the non-Malays? If I would be tempted, that's my problem. That's not the problem of the canteen owner. It's Muslims who must strengthen their faith. I had a Pamariksa Lua external examiner from Australia coming to my faculty. It happened to be the month of Ramadan, but he's a non-Muslim. He is not fasting. What should I do? Ask him to fast? Actually, I requested my family to cook a meal for him. I lived near the university. I drove him to my house for lunch. He sat down and had his lunch in my house at my table with me sitting next to him. And my faith was not shaken at all. In fact, I'm quite sure that I got some extra credit that day. So I don't understand all these practices. This is unnecessary. That during the fasting month, restaurants must close down because some Muslims, if the faith of Muslims is weak, then I think we need to reinforce this faith rather than to impose restriction on others. Superior courts, superior civil courts are disregarding Schedule 9 by asking non-Muslim women to go to the Sharia courts. Article 3 on Islam is overriding Article 4. Article 4 says, this constitution is the supreme law of the Federation, and any law passed after Mardekade which is inconsistent with it shall, to the extent of the inconsistency, be void. And I read to you Article 3 Clause 4, which says, nothing in Article 3 Clause 1 derogates from the Constitution, but our superior courts are disregarding. Islamic State and Hudud, this polemic of whether Malaysia is an Islamic state or not, comes on again and again. Let me just say this to you very frankly. Don't waste your time about this debate. Are we an Islamic state or not? Don't waste your time. It is an issue of semantics. It's a question of what you mean by an Islamic state, or what someone else may mean by an Islamic state. So one definition of Islamic state is Muslims are a majority, in which case, well, yeah, we're an Islamic state. Or another definition could be Sharia should be the supreme law of the Federation, in which case we are not an Islamic state. There are many other definitions. Who is in power? Who is in power? That's one definition. So it's an issue of semantics. Don't waste your time about it. Basically, live a good life, be noble, be honest, be truthful, be compassionate, be merciful. I think that's the best evidence of being a good Muslim or a good person of any religion. Then there is hudud thing comes on now and then. Obviously, elections are around the corner. Why? Hudud issue is raised. Every time elections are coming, the hudud issue is raised. It's a very clear indication, that elections are around the corner. Well, the Hadi bill, RUU 355. By the way, there have been several versions of the Hadi bill. The 2016 May or June version was rather, should I say, the pure version of Islamic fiqh, because much of hudud actually is not in the Quran, much of hudud is fiqh. I know that this is a dangerous statement to make, but lot of what is called the hudud actually is not just found in the Quran. Actually, it is part of Islamic jurisprudence, the fiqh. The June version was quite traditional, but the present version is very innocent, looks innocent, looks innocent. It is basically under the Sharia Courts Criminal Jurisdiction Act 1965, the penalties that are allowed to the Sharia courts are 365, 3 years jail, 6 whips, and 5,000 ringgit fine. Very, very modest penalties. Penalties are lesser than the penalties that can be imposed by second-class magistrates. So that was the intention of the Constitution in 1957, 1965, that Sharia courts will deal with minor offences. YB Hadi wants to raise 3 to 30. 3,000, 3 years jail to 30 years jail, and 5 and 6 to 100. So basically he's increasing the penalties. The increase is very drastic, but nevertheless he's saying, look, all that we are doing is we are increasing the penalties. What's your problem? And the penalties will apply only to Muslims, so why are non-Muslims complaining? However, let me point out to you that the real situation is this, that RUU 355 seeks to put in operation, either in whole or in part, the hudud laws of the past government in Terengganu and Kelantan, which are blatantly unconstitutional, which seriously trespass on federal jurisdiction, and which violate the fundamental rights. I have been informed that my free speech has to be subject to some responsibility. Time is up. So I'll try to finish up. I just want to mention this to you. To raise the jurisdiction of the Sharia courts to impose penalties may be justified, because as I said earlier, Sharia courts have jurisdiction equivalent to that of second-class magistrates. But you see, one constitutional point that you should please bear in mind is this. At the moment, almost all the Sharia enactments have unconstitutional parts, in the sense that almost all the Sharia enactments are punishing crimes, which crimes are clearly outside of the jurisdiction of the states. They are punishing homosexuality. They are punishing betting and gambling. I don't support betting and gambling, but these are federal offences. But Sharia enactments are punishing them. In Terengganu and Kelantan, even murder, theft, robbery, incest, rape are being punished. These are actually federal offences. So I think before the penalties are enhanced, there should be constitutionalization. Otherwise, we are rewarding unconstitutionality. There is suppression, there are limitations of special concern to Muslims, suppression of diversity in Islam. I don't have the time, but I just want to mention this to you. Islam, like all other religions, is a mansion with many rooms. There are many views of the Islamic garden. I look from this window, I see a different garden. I look from that window, I see a different garden. On issue after issue, whether it is beating of your wife, Surah An-Nisa 34, whether it is apostasy. Last night, Prof. Chandra Muzaffar pointed out that actually it is a sin, not a crime. Whether it is cutting of hands, Surah 5, 38, Ayah 38, the concept of iqta'a. Whether it is unequal inheritance for females, whether it is triple talaq, whether it is polygamy. Let me tell you this, on all these issues, there is richness of Islamic thought. Now, the problem that exists in this country is this, and many other countries is, and on this it is not just the very conservative. I've heard doctors, I've heard lawyers, educated people say, no, you can't talk about Islam because you are not an Al-Azhar graduate. In which case, please don't talk about road traffic unless you have a transport degree. Don't talk about the Constitution unless you have a PhD in constitutional law. Don't talk about the economy unless you have a PhD in economics. Don't talk about anything unless you have a related PhD in that area. Now come on, we are all allowed to think. The Holy Quran requires us to think, not to follow anything blindly. I don't have the power to make a ruling on that matter. I don't have the power to issue a fatwa on that matter. But if I can go to a religious scholar and say, Tuan, on this issue, I found this material from Al-Azhar, or I found this hadith, or I found this sunnah, I found this piece of writing. What's wrong with that? What's wrong with allowing Muslims respectfully to point out that diversity is an essential part of Islam? It has always been and will always be. You can't suppress ideas. You can send the person to the jail, but the ideas can never die. So I think there's this problem, suppression of diversity in Islam. Then there is this issue. I have an answer to that, but sadly the trend is the other way. Fundamental rights of Muslims, all Muslims, are also entitled to fundamental rights in Article 5 to 13. All fundamental rights of Muslims are being regarded as subject to Sharia law. So it is not Schedule 9, List 2, Paragraph 1 that is subject to fundamental rights. It is fundamental rights that are subject to Schedule 9. Schedule 9 is the power of the state assemblies to pass laws. So this is a new development, that fundamental rights chapters are being subjected to the power of the state assemblies rather than the other way around. Offenses against Islamic precepts. The Sharia courts have been given the power by state assemblies to punish offenses against the precepts of Islam. Now what's a precept of Islam? When the Constitution was drafted, we thought precepts of Islam mean the Rukun Islam, the Rukun, basically to interpret the words narrowly. But now actually the way the interpretation is, anything which relates to Islam can be punished. So basically what is happening now is the federal state division of power. Crime is in federal hands, family law is in state hands. What is happening is that division has been nullified, because as long as it is something about Islam, the state assemblies have the power to pass law. I just take 2 more minutes, sir. I'll do an overview. There have been the dissonance between constitutional theory and constitutional practice, and Islamic theory and Muslim practice. Islamic theory and Muslim practice. This dissonance is quite large now. Partly it's the result of the policy of Islamization, which was a good policy, but it has gone astray. It is enforced overzealously by some administrators. Form over substance is emphasized. In such an atmosphere, some Muslims have come to believe that acts of intolerance towards non-conforming Muslims and the disbelievers makes them better Muslims. I don't think you become a good Muslim by hating others. I think you become a good Muslim by being true to your faith. There is oppression of Muslim nations by the West in many areas. I mentioned to you earlier how many Muslim countries are under occupation, and I think this is radicalizing many Muslims. Consequences of Islamization are there's a tremendous expansion of the Sharia establishment. I understand nearly 100,000 posts have been created at the federal level and in all the 13 states. When it comes to teachers and officials, vigilantes, nearly 100,000. The fiscal allocation just for Wilaya, Persekutuan, Sharia authorities is I think more than 500 million per year. the passage of Article 121A, which has caused a lot of problems, the desire of some Muslim elites to indigenize the Malaysian legal system. By indigenization, they mean actually Islamicize the legal system. Very large number of Malay graduates are returning from abroad. They have to be given jobs, and jobs are created. Sharia authorities have emerged as a sort of meta-legal fourth branch of the government who are not answerable to the courts or the constitution. This is the Malaysian version of the deep state. I'm sure you are familiar with the concept deep state. Deep state means in every country there are agencies, persons, authorities who are not given power by the law, but who actually wield the real power. Like in the USA, the industrial military establishment, the bankers, the lobbies. They don't really have the power to make decisions on war and peace, but they determine. Well, Sharia authorities have become the deep state. Islamization has further complicated the challenges of legal pluralism. In some countries, we try to harmonize the various legal systems. We walk the middle path. In Malaysia, we appear to be heading in the opposite direction of creating parallel legal systems that may result in one country, two legal systems. Arabization of Malay society is in full swing. I don't know what has happened to my Malay colleagues. Are there any Malay colleagues left? No, there are Arabs everywhere. I don't know to what extent Saudi petrodollar is fueling this direction is unknown. There is tremendous cooperation between the religious and political elite. You protect me, I protect you. Recommendations: we need to reconstruct religious thought. Don't have the time for that. Religion can be marshaled to foment and to rationalize war and conflict against people who behave and believe differently. Religion actually can be used for any purpose that you want. It's an instrument. We have to open the gates of ijtihad, especially in the Sunni world. Ijtihad is closed, reason is shunned, not just by the fanatics, but by the vast majority of Muslims today. Suppression of thought characterizes many Muslim societies. I have a lot of suggestions, but I'm sorry, time is up. Let me just go to the last paragraph. Malay Muslim society has historically been very accommodative, inclusive and tolerant. Prof. Chandra also made that point yesterday. I think we need to recapture history and to return to the spirit of tolerance, accommodation, and compromise that animated the forefathers of our constitution, and that I think animated Malay society in general. I've said this on other occasions. That's my last sentence, sir. The forefathers of our constitution, the Malays, the non-Malays who drafted our document of destiny, I think they should have been nominated for a Nobel Peace Prize. Not because they ended a war, but because they created conditions of peace. I think we have a good constitution. With all its flaws, it is a workable document. Many countries are trying to snatch victory from the jaws of defeat. They're trying to reconstruct. They're trying to harmonize. They're trying to unite. We in this country are trying to snatch defeat from the jaws of victory. You know, we have a winning combination. Please keep it that way. No radical changes are needed to our legal system. We have a winning combination. We want to do away with it. Others actually want to emulate us, but we want to alter our direction and to go a new way. So please keep this country safe, keep this country united. We have a tradition whereby actually we have proved to the world that we can maintain it that way. And thank you very much.